Also, to remind those present, since the public is permitted to view this, we're using a YouTube link. It's being recorded. I think your device may ask you to acknowledge OK for that recording. So if you haven't yet done so, take a look. Something should pop up on your screen indicating this is being recorded. And I think it needs you to acknowledge that. Good morning. It's now 8:30, which is the scheduled start time for this hearing. I'm not seeing Judge Flood, and I'm not seeing Ms. Bremner nor other counsel from her office on screen. Ms. Martin Jones, do you know when we can expect them?
Anne Bremner's with
Good
me right
morning.
now.
Great. And so will she, good morning, Ms. Bremner. Will you be
Morning.
there under Ms. Martin Jones' caption there then?
Yes, we're together.
I see. Okay, great.
In the conference room. And Judge Flood should be on shortly, and then my co-counsel Nick Gross is on his way, but we're prepared to start. At least I'll be counsel for entry of the stipulation this morning and addressing the commission.
All
We're
right,
not
thank
waiting
you.
for him, in other words, for
Okay.
Nick Gross.
I'll defer now to the presiding officer, Judge Price.
Good morning, everyone. This is a public fact-finding hearing in the Washington State Commission on Judicial Conduct in the matter of Judge Tracy Flood of the Bremerton Municipal Court. The commission's case number is 11005-F-204. My name is Judge Eric Price. I am the appellate judge member of the commission. I have been and will be the presiding officer of this hearing. I do have one preliminary matter that I'd like to address, which is three submissions by Judge Flood that have not been ruled on with respect to whether they are sealed or not. But I also want to make sure that Judge Flood is with us. But first, I will let me say good morning to our counsel. Ms. Rasnick, good morning.
Good morning, Your Honor.
And Ms. Bremner, good morning.
Good morning, Your Honor.
And Ms. Bremner, what can you tell us about Judge Flood's whereabouts?
Momentarily, she'll be on, Your Honor. She might be a few minutes late, like at our hearing, and we appreciate any indulgence, but stipulation's been something being worked up on up until this minute. We're trying to keep in touch with her. So maybe by the time I'm done talking, she'll be on here, but shortly, I hope.
Okay, well, I was going to ask the parties if they had any preliminary matters, and you've used the word stipulation now, I think 2 or 3 times. So it sounds like the parties do have something they want to address before we get started. Ms. Rasnick, let me ask you, do you believe we should be going forward without Judge Flood's presence at this point?
No, Your Honor. I think I'm happy to give her a couple more minutes. And as to a stipulation, certainly there has been a lot of discussion. Nothing has been signed, so perhaps that's something that will fall into place within the next couple of minutes as well. But I'm prepared to proceed on discussion of those documents for which sealing had been requested.
Okay. Ms. Bremner, what are your thoughts on whether we can address the sealing of the documents in the absence of Judge Flood's presence?
Well, I think we can, Your Honor, because that has been a request and she's been present for those requests, or at least been part of the filings.
Okay.
And we could also address, Your Honor, the timing of how we'll proceed from here if indeed a stipulation is fully entered this morning, because I think that there's an indication from counsel, an agreed indication, that we would be starting up on Wednesday, going through Friday, dealing with the stipulation. So maybe we could deal with scheduling potentially as we look at the commission, their
Okay.
availability. I know they were available all week, as were you, but
Let's not get ahead of ourselves just yet.
Okay.
I'm not sure the panel has any awareness. I only have a marginal awareness of what you are referring. So let's hold
Okay.
off on that.
Thank you, Your Honor.
And let's address the sealing of the documents first, because I agree that we can deal with that issue in the absence of Judge Flood. There have been, by my count, 3 submissions that have been made, ostensibly in response to the presiding officer's order to provide information regarding health updates and scheduling updates from Judge Flood. The ones that I believe have not been addressed thus far are one submission that was submitted, commission file date August 12th, 2024. It's a 4-page document, a 1-page document that I have dated September 9th, 2024, and then a 2-page document from September 20th, 2024. That's what I understand has not been addressed yet. Let me ask first, Ms. Rasnick, do you believe that there are other documents that the presiding officer has not addressed regarding submissions?
Your Honor, by my count, there was a document, a declaration filed by the judge on August 12th. I have a declaration, a 1-page declaration, and then there were also about 3 or 4 pages of records that were attached to the declaration as I received it. And then the declaration filed September 9th is simply a 2-page declaration. The September 20th document is also a 2-page declaration. So those are the dates. I just wanted to make sure that we're all considering the same things.
Ms. Bremner, do you have any different information?
I don't, Your Honor. Thank you.
I'm pausing because I have 1 page for September 9th, and I want to make sure I know everything else that you said, Ms. Rasnick's consistent with my understanding. The 2-page on September 9th, I'm assuming the first page is a cover declaration. Is that correct?
Your Honor, I have a 2-page declaration. Just the caption just says Declaration of Judge Tracy Flood, signed September 9th. It has 3 paragraphs. It's a 2-page declaration. I believe there was a separate record, may have been filed separately. Maybe that's the difference. Is the court looking at a declaration or a record?
It's a record.
Okay. I am looking at the declaration. So it's unclear to me whether the request is simply to seal the record or to seal the declaration and the record.
It would be both, Your Honor. She has some substance in it. Okay.
Well, my apologies while I try to find the 2-page.
Your Honor, I am also understanding that Judge Flood is currently presiding over a calendar. And so given that, I'm wondering if we could get a realistic time when she might join us this morning.
Ms. Bremner, can you explain, if that's true, why there is a calendar that Judge Flood is handling at this moment at 8:37?
I have no knowledge of that, Your Honor, and I'll follow up now. My understanding was she was running a little late and would come on the call on a Zoom hearing shortly.
If you can convey to Judge Flood as you communicate with her, her necessity for her attendance
Yes.
at this hearing that has been set for some time for 8:30?
Absolutely, Your Honor. Thank you. Can you email or texting? Are we unmuted?
Yes.
Thank you, Your Honor. Can you hear me okay?
And
Okay. She was not presiding over a calendar. I just talked to her briefly. She's getting on now. She was entering an order. But that I don't think she decided to go and sit on a calendar, Your Honor, and ignore this Your Honor and the commission in this important hearing. So we just sent her the link again and she should be on. She's trying to log on and having issues according to Nick Rose. And so we've sent her the link again. He just talked to her too. Is that
it would
Tracy?
appear that Judge Flood has now joined us. Good morning, Judge Flood.
Yeah.
Good morning.
Okay, this matter was scheduled at 8:30. The time is now 8:41. In that space of time, I have, however, found the two-page declaration from September 9th submitted. So let me make the record clear. At this point, we are dealing with, as I termed it, a preliminary matter of the three submissions from Judge Flood that have not been ruled on with respect to her request to have them sealed. First is a submission from August 12th. It is a one-page declaration with 3 attachments. Second is a 2-page declaration from Judge Flood on September 9th, and then a separate single-page record also filed on September 9th. And finally, a 2-page declaration from Judge Flood dated September 20th. And filed September 20th. Now, Ms. Rasnick, did you have any further information regarding the documents that I'm dealing with at this point?
I don't have any further information about the documents. I can convey disciplinary counsel's position on the request to seal when Your Honor is ready.
Okay. Anything from you, Ms. Bremner, now that I have clarified the documents I have in front of me?
No, thank you, Your Honor.
Okay. Ms. Rasnick, did you want to make do you have comments regarding the request to seal?
Your Honor, starting with the declaration attachments dated August 12th, disciplinary counsel doesn't have any objection to sealing the medical report. That is how it is described in the declaration, but does object to sealing the declaration. Don't believe the information in the declaration is of the type that justifies sealing. And then under going to the September 9th declaration, same approach, Your Honor. We would agree, disciplinary counsel agrees that the attachments, so the medical record portion of the document should be sealed, but the declaration itself doesn't meet the requirements for sealing. And then the September 20th document is simply a declaration, which don't believe meets the requirements for sealing. So our disciplinary counsel's position is the September 20th document should not be sealed.
Ms. Bremner?
Your Honor, we disagree, given that these declarations, I'll go in reverse order, that dealing with the last first, she talks about in her declaration about a surgeon, medicine testing, etc. I don't want to go into all the details because that's the whole purpose of sealing it, but it talks about what kind of testing and what the follow-up would be, and further scheduling of tests. Talks about her actual condition, what she's been battling, and it's very specific as to what that is. And then the other declaration, going in reverse order, talks about procedure, surgical procedure, etc. So I think
Ms. Bremner, I believe you've moved away from the microphone. We cannot hear you.
Okay, sorry, that was not of my doing, but thank you. For the same reasons, I mean, the second declaration in reverse order, Your Honor, is not as detailed as the one I've just described, but clearly talking about her procedures, and medical information, and so it should be sealed just as the record should be sealed, and as previously requested.
Ms. Rasna, anything further from you?
Your Honor, I think redacting the declarations to protect the specific procedures and tests would be a fine way to address this, and a lesser burden on the public's right to see this information than sealing the entirety of the declaration. So we'd ask that if the court is inclined to grant a motion to seal, that instead the documents be redacted.
Thank you. So I'm going to undertake what's shorthand known as a bone club analysis. That name comes from a case. Not sure what the two parties are, but one of the parties was Bone Club, and that requires the court to balance the interests of the public with the interests of the person who is seeking sealing of information. Part of the Bone Club analysis requires the presiding officer to request solicit rather any objection from members of the public to the sealing of the documents. I'm going to first ask if anybody on the call objects to the sealing of the documents. Hearing none, I am aware that this matter is being YouTube streamed, which means that the members of the public do not have an opportunity to object as if they might if they were on the call. I'm going to use my recollection from the last time we had this hearing that had members of the public actually on the call, and there was an objection from a member of the public to the broad sealing of documents. And I'm going to assume if there was a member of the public, if that member of the public had access to this hearing, that he or she would make a renewed request or renewed objection to the closure. So I'm going to assume there is an objection. And with that, I'm going to balance the request for the documents to be sealed with the interest of the public in seeing the information. I'm going to make the following decisions with that balance and with an eye towards the least restrictive method to seal the information. And that is, let me take them in pieces. With respect to the first submission, August 12th, it is a one-page declaration of Judge Flood and 3 pages of attachment. The first sentence of the declaration, lines 14 and 15, shall be redacted. The remainder of the declaration shall be available for the public. Let me make that clear. The first sentence of the declaration, line 14 and 15, shall be redacted from the document. The remainder of the declaration shall be available. All 3 pages, all 3 attachments shall be sealed. So just to make that clear, with respect to August 12th, lines 14, 15 shall be redacted. The declaration otherwise shall be available, and all 3 attachments shall be sealed. With respect to the submission on September 9th, this is a 2-page declaration of Judge Tracy Flood and one attached page. I'm not sure it's actually attached or not, but it is a record and it's entitled Department of Veteran Affairs. Again, balancing the interests of the public as well as the interests of Judge Flood and sealing of private information. With respect to the declaration, paragraph 1, lines 14 through 18 shall be redacted from the document. The remainder of the declaration, the 2-page declaration, shall be available to the public. Again, paragraph 1, lines 14 through 18 shall be redacted. The remainder should be available for the public. The 1-page attachment, if it is attached, again, entitled Department of Veteran Affairs, filed September 9th, shall be sealed in its entirety. With respect to the submission on September 20th, this is a 2-page declaration of Judge Flood. The entirety of the declaration shall be sealed. Any questions or clarifications with respect to the presiding officer's decision, Ms. Rasnick?
No, Your Honor, thank you.
Ms. Bremner?
No, thank you, Your Honor.
Okay. Our clerk today, I think, is Ms. Baldos. Any questions with respect to those documents from the staff that is going to be tasked with executing on the rulings? Ms. Baldos?
I have no questions. I'll execute your decision.
All right, thank you very much. All right, so now moving on, now that we have Judge Flood with us, I understand the parties have something they want to raise before we get started on the hearing. Who wants to speak first? Ms. Rasnick?
I can give a quick summary. Your Honor, the parties have been engaged in discussions about a stipulation. It is not a full stipulation pursuant to Rule 23. It is a stipulation that would narrow the issues and narrow the presentation of evidence if accepted. However, nothing has been signed. And so that is what I can report, that there have been talks, but there is no signed stipulation. I would appreciate hearing from respondent in that regard.
I have just one moment, Your Honor. I should say Mr. Gross is here now and logging in here at my office. We have a stipulation, Your Honor. Counsel and Mr. Gross from my office have been working on it quite a bit, including throughout the entire weekend. All we have left to do is as counsel says, to finalize signatures. So maybe we could recess and do that, or I'll ask the court's indulgence, but the stipulation, as I understand it, is agreed from our end.
So help the panel and me understand what we're talking about. What's the stipulation? What is?
Sure, I'm happy to speak to that with the understanding that respondent will in fact be signing this stipulation. The stipulation involves some stipulated facts, stipulation to some violations of the Code of Judicial Conduct, and contemplates that this proceeding would go to hearing on the issue of sanction, and provides for the number of live witnesses that each party would call, provides that respondent would testify, provides that each party would then submit some testimony in the form of sworn affidavits or declarations, and allows for the cross-examination of declarants whose testimony would be submitted by declaration. So this, Your Honor, is the effort to streamline this proceeding that I believe there was some reference, I believe back in February, to perhaps trying to make this happen. So we have at last, hopefully, made it happen. That's the best summary that I can give. Obviously, this is subject to the approval of the panel. It will be easier to, I think, for the panel to understand once we are able to provide them with the document. But happy to answer specific questions.
Ms. Bremner?
I absolutely agree with everything that was just stated, Your Honor. Thank you.
What is your proposal with respect to securing the signature on this this proposed stipulation?
I think we need about 15 minutes, Your Honor. Perhaps we could take a recess and we can get it done.
Ms. Rasnick?
I'm happy to take a recess for 15 minutes. Ms. Bremner's office has been taking the laboring oar with the preparation of the document, so I'm assuming that it would be circulated to me for signature.
Ms.
Yes.
Connor has.
I just had a suggestion since Judge Flood is on the video and we're awaiting a signature. Obviously, council have been working late into the 11th hour for this. If we could just get a verbal affirmation from Judge Flood that she's aware of what's been represented by both counsel and it is her intention to sign an accurate document.
Right, Ms. Connor is suggesting that Judge Flood orally represent that she's in agreement with the stipulation. Ms. Bremner, any objection to that?
No, Your Honor.
Okay. So Judge Flood, you are on the call. Let me ask you, your counsel is representing that there's a stipulation that has been circulated that you are intending to sign. Is that true?
There is a stipulation that has been being worked on, as my counsel has indicated. And if it is accurate, I will execute my signature on it. But I have not seen the version from this, I have not seen a final version. I guess that would be the most accurate way to indicate them in the record truthfully.
Ms. Bremner, what's your level of confidence that this can, the signature can be secured in 15 minutes?
I have a high level of confidence, and there have been some last minute changes occurring as we were coming on the call. So that's what she's speaking to, I believe, and I have a high level of confidence. 15 minutes, I think, will be sufficient.
All right, so let's do this then. Let us adjourn until 9:15. That's actually 20 minutes.
Okay.
9:15. We will all maintain the call. I will
Okay.
ask the panel members, you can turn your cameras off and remain muted, but we will resume at 9:15 sharp. We'll be in recess.
Thank you.
You want coffee? Yeah. Good coffee.
We're on.
Let's see.
All right, so the time is now by my computer 9:15. We are resuming the fact-finding hearing for Judge Flood. I thought, no, it looks like Miss Connor has lowered her hand.
No, not on purpose.
Oh, you still have your hand up, Miss Connor?
Thank you. I just wanted to advise presiding officer, the panel, and those others present that this commission office received a voicemail from an attorney, Robert Davy, who was in fact the person that Your Honor had referenced, who had objected at a prior flood hearing in regard to the sealing of documents. Mr. Davy is currently watching on YouTube, and he did hear Your Honor use your prior objection as a standing objection, appreciated that, stated he's willing to go on the record for the objection at this time as well, and just wanted to confirm your assumption.
Okay, so Mr. Davy was watching on YouTube, and as I expected, had he been participating on Zoom as he had previously, it sounds like he would have made an objection, which I had anticipated. So, okay, so we're now resumed. The reason we took a 20-minute break was to secure a signature on a stipulation, the details of which we do not have. Ms. Bremner, what can you tell me?
Apparently we're circulating it through DocuSign, and I'm looking at Mr. Gross's here. Is everybody signed from our end? Yes or no? I know, but have we signed from our end? Okay. We're waiting to get it back from CJC Council, Your Honor, to sign.
Okay, but Judge Flood has signed?
We're waiting to get it back from CJC Council for all of us to sign, including Judge Flood.
Your Honor, my staff was asked to facilitate the Adobe sign so that everyone could sign. I was informed that that was the only way that we could go forward. I just got the PDF. I am reviewing it to confirm that my last two proposed changes were incorporated. It appears that they were, so I am now going to ask my paralegal to circulate it via Adobe Sign to Judge Flood and her counsel, and to add my electronic signature.
So, Ms. Rasnick, what are you telling me in terms of the duration that you're expecting this process to take?
Your Honor, yeah, it will take 1 minute, maybe 5 minutes for my paralegal to add my electronic signature and send the document on to respondent's counsel and respondent. It has to be sent individually to them at their individual email addresses, because that's how Adobe Sign works. I will not have any control over how long it takes respondent's counsel or respondent to execute the Adobe Sign.
What are you proposing in terms of what we do with the panel?
Sure. I am proposing that we recess for an additional 15 minutes at this time, Your Honor.
Ms. Bremner?
Agreed, Your Honor. Thank you.
Do we need 15 minutes, Ms. Bremner?
I don't know if we need it, Your Honor, but I hate to come back on when we're not ready again. I think it should be 5 minutes. Right?
Okay, the Adobe sign is going out.
It is 9:18. We will resume at 9:25. 9:25.
Thank you, Your Honor.
Honor.
We're muted. That's to say.
All right, the time is now 9:25. Ms. Bremner, what can you tell me?
I've signed and Mr. Gross has signed and we're checking now with Judge Flood. She's been reviewing it. Is she on? Oh, not yet. And we're calling her right now again.
No, Judge Flood's right here.
And Judge
So,
Flood is.
Your Honor, my apologies. I signed it, but then it told me it had some changes because I think we were all signing at the same time. So I had to re-sign. I had to re-download and sign again, but I
Okay.
believe it should be.
It's
Hopefully.
signed. We have it, Your Honor. It's signed.
Okay. All right, so we now have a signed stipulation, and I think the panel and myself are still in the dark on what this stipulation is, what it's about, and what the parties intend for the panel to do. Ms. Rasnick, I'll turn to you.
Your Honor, my paralegal is sending the fully executed stipulation to Ms. Baldaws and to Respondents Counsel, so we will all have it. It might be more efficient to take it up when we all have it in front of us. But it should take, so she is sending it to Ms. Baldaws right now.
Okay. Well, actually, I'd like a summary first.
Sure. Happy to. Your Honor, the factual stipulations support violations of Rule 1.1, 1.2, and 2.8B. There are, sorry, someone is talking.
Go ahead. Sorry, I was just pulling it up. Thank you,
Okay.
Counsel.
There are factual stipulations to support those violations. There are stipulations that acknowledge the judge's perspective on what has happened in Bremerton Municipal Court, as well as the perspective of the employees. It's not an exhaustive factual stipulation to every single fact. This case has been pending for a while. And the anticipated path forward is to, if the stipulation is approved, have 2 days of testimony pertinent to the issue of sanction. We have agreed to Wednesday and Thursday of this week. If the stipulation is accepted, each party would be presenting 6 live witnesses, and I believe an additional 6 sworn declarations, with the parties to have the ability to call the declarants for cross-examination. If Your Honor would like me to go into more granularity about the facts, I certainly can do that, but that's the high level.
So, Ms. Bremner, let me get your high level.
That's my understanding, Your Honor. And that's our agreement, Your Honor, as to how to proceed.
What is anticipated in terms of duration of, you say 2 days. Is it 2 short days, 2 long days? What's your expectation, Ms. Rasnick?
I believe we are contemplating 2 long days, Your Honor, because we've got, certainly 6 witnesses each to do direct and cross and redirect, and then possibly some cross of the declarants. And we've left open that if there needed to be a little bit of additional time, either party could request the additional time, and perhaps the additional time could happen on Friday or at an additional such date as the court would order if additional time is needed.
So it's 6 witnesses each or 6 total?
Each.
Ms.
Up
Connor,
to 6. Sorry, I'm sorry, Your Honor. I didn't mean to speak over you.
up to 6 each,
Yes, Your Honor.
not including potential cross-examination of declarants?
Correct.
Ms. Connor, your hand's up.
I know that the panel and you have yet to rule on this. It's been extremely difficult to get to this point just logistically in terms of clearing schedules and so forth. If the panel is inclined to grant this joint motion to accept the stipulation, I would ask that Friday remains as scheduled, devoted to this matter, so that rescheduling doesn't have to occur following that.
So they would have 3 days.
So what do you propose? Well, first of all, there is rule of procedure for the commission 23 that talks about stipulations in exchange for an agreed sanction. What's your response? First of all, I'm expecting now. Ms. Connor just used the word motion. I guess I'm hearing a joint motion from the parties to have the panel accept the stipulation, or I'm assuming that that's what's technically being done. So, Ms. Rasnick, what's your position with respect to the Rule 23 and the fact that this does not appear to include an agreed sanction?
This is not a stipulation pursuant to Rule 23, Your Honor. So we are not and yes, I do agree that we are jointly moving that the panel accept the stipulation, but I do want to be clear, this is not a Rule 23 stipulation because there is not a proposed sanction. What this stipulation does is to get some factual issues off the table, take them out of dispute. The respondent has stipulated to violations. The respondent has stipulated that any sanction should include, I think, sorry, I'm looking for it in the document right now, that any sanction should include a program of counseling, mentoring, and coaching. So there has been some agreement to a portion of a contemplated sanction. But it is not a Rule 23 stipulation in that there is no firmly agreed upon sanction, and we're planning to proceed to take testimony on that issue.
How long of a document is it?
It is 11 pages with the signatures.
Ms. Bremner, what do you want to say?
Your Honor, only that with respect to Ms. Connor's request, I don't have a problem with going through Friday. We've had the whole week reserved, of course, for the hearing. And we agree with counsel's summary of what this is in terms of being a stipulation, but not one under the rule which would have an included sanction stipulated to, because we haven't. That's what the hearing would be for.
So, Ms. Rasnick, I'm interested in what you propose that the panel do with this motion. Do you propose that the council go through the document with the panel? Are you proposing that the panel take the document and discuss it amongst ourselves after reviewing it? What do you want us to do?
Sure. I think it would be useful for council to go through the document with the panel. I believe that would be an efficient way to proceed, and would allow to perhaps surface any initial questions.
Ms. Baldos has her hand up.
The proposed stipulation has been received and added to the panel's folder for this hearing.
All right, Ms. Bremner, what's your take on that proposal to have the attorneys go through it with the panel?
That's no objection, Your Honor. We agree.
Okay, let me just get a show of hands from before we go through that process, does anybody on the panel want to share something privately with the panel? In other words, does anybody, before I make a decision on whether we're going to go, which process we're going to take, does any member of the panel want input on that privately?
Your Honor, can I have time with my attorneys? I need a moment, please.
We request that, Your Honor.
Do you need a breakout room?
Yes,
thank
please.
you.
So at this point, I guess we'll have a breakout room with Ms. Bremner and and Judge Flood. Gareth, how do we know when they want to come back?
They can just re-enter the meeting from the breakout room when they're done.
Okay.
Exactly. Yes.
So while that happens, I guess I'd like to have a breakout room with just the panel.
Okay.
Your Honor, would you like me to be included with that as a commission counsel?
Yes.
Thank you.
I'm going to put Judge Flood and her counsel in a room first, and then I will put the panel in a separate breakout room.
Can I just interject for a second? Please, Nick Gross is on now, my co-counsel. I want to make sure he's on the breakout room too.
Absolutely.
Thank you so much.
Your Honor, I'll just remain in the main session and turn off my video and wait for everyone else to rejoin me.
Sounds prudent.
Should I ask for who gave that information?
Okay, so we're back. Panel did take a excuse me. The panel did take had a breakout session in which we had some discussions. Ms. Bremner, you appear to be back from your breakout session with your client. Have you concluded that?
We have, Your Honor. And thank you.
Okay. So my apologies. I have a little bit of an illness. So Ms. Rasnick, I'm going to turn to you first. You proposed prior to the pause in the proceedings that the attorneys take the panel through the stipulation. I believe that all panel members now have either in front of them or access to it. Are you and Ms. Bremner going to sort of go through it together? Are you what do you want me to do? Ask you one at a time? What's your proposal?
I have not discussed this with Ms. Bremner. I can certainly go through it and Ms. Bremner can chime in, or I can go through it and then she can go through it. I'm happy to do whatever would most facilitate the panels being able to consider this.
Ms. Bremner?
Thank you, Your Honor. Mr. Gross, from my office would like to address this.
Mr.
Hello,
Gross,
Your
good
Honor.
morning.
Good morning, Your Honor. So a couple things. One thing we wanted to clarify, there was discussion about scheduling of a third day, and the stipulation addresses this clearly, but we just want to let the panel know that we are not, there's no pre-agreement for a third day of testimony. The anticipation is 2 days of testimony, but the stipulation says that either party can motion for additional time if need be, but that would be subject to objections from the other side. So that's one thing we wanted to make clear. And the other thing is that part of this stipulation is that the disciplinary council is not going to be asking for a censure with removal, which is also inside the stipulation. As far as going through the stipulation kind of line by line, we would prefer not to do it that way. We would prefer that the panel adjourn and review the stipulation and deliberate about it, and if there are questions to come back. So that's our preference.
Ms. Rasnick?
I don't have any objection to proceeding in that manner.
Help me understand your perspective, Ms. Rasnick, about this third day issue. What do you, and I guess what does that mean that there's going to be opposition or potential opposition to a third day?
Sure. Your Honor, I think this arose out of the agreement to present some declarations in addition to the live witness testimony. And the agreement obligates the parties to provide the declarations to one another by a time and day certain. And we were anticipating a need to confer about the need for additional time once we have exchanged the declarations. And I anticipate what would happen is we will then be able to determine whether we can jointly request additional time, or if there's not a joint request, then either party would be able to make the request for additional time. But certainly a request by one party would fairly need to be subject to objection by the other party, and then obviously subject to whatever the presiding officer would order. If that answers your question.
Yeah, I may have more questions about that as we move on. As a presiding officer, obviously, I'm keenly aware that there is certain obligations that the presiding officer has with respect to keeping things moving, and I want to make sure I understand the perspectives of the parties regarding what that means and doesn't mean in terms of their scheduling.
I mean, sorry, Your Honor, didn't mean to speak over you.
I was just going to say we don't have to talk about that now. I'm more interested in getting the stipulation before the panel in a meaningful way. I'm not sure I agree with Mr. Gross that it makes sense for us to just go back and muse about it ourselves. I would like a nickel tour here, Ms. Rasnick, and since you offered to do that, I'd like to have you do that. You can start on page 1 and just give your 5,000-foot summary of what we're looking at.
Sure. Your Honor, the stipulated facts, I would say going up through about paragraph up through paragraph N. No, paragraph M, sorry. The stipulation through page 4. So up through actually paragraph L. I'm sorry. This is a function of our having re-lettered paragraphs. The initial paragraphs describe what I would broadly describe as, what Judge Flood experienced, Judge Flood's background, the significance of Judge Flood taking the bench in January 2022 as the first Black woman to have been elected to that position in Bremerton Municipal Court, and acknowledging some of the things that she experienced in that position. There's some detail about the things that she experienced in that position. And then beginning with paragraph M, which is on page 4 of the PDF document, kind of shifts perspective to what the staff experienced under Judge Flood's leadership. And there's an initial kind of summary paragraph detailing the broad concerns of staff. And then in paragraph N, which starts on the bottom of page 4, a list of some specific instances of misconduct. And those specific instances go through midway through page 7. Then there is another shift to kind of some information about the functioning of the court, resources that the court needed to draw on to be able to continue functioning, given the staff turnover that it experienced. There's some information about the role of the City of Bremerton's Human Resources Department, or lack thereof, in being able to address staff issues. There is, let's see, the last paragraph. Looks like there's some formatting weirdness on page 8, but the paragraph that is lettered S on page 8 acknowledges that the effective respondent's conduct on staff and attorneys before her had been brought to her attention. And then Roman numeral 2, which should start after lettered paragraph S, but it looks like there's some formatting strangeness, picks up on the bottom of page 8. And there we have the stipulation to the violations of rules 1.1 and 1.2 and 2.8b. And it goes through the next few paragraphs explaining what those rules say. And then on page 9, paragraph 4 revisits the issue of some of the hurdles that respondent faced as in her position as judge at Bremerton Municipal Court. And then in paragraph 5, we have an acknowledgement that notwithstanding the hurdles, respondent is bound by the Code of Judicial Conduct and has to comply with it, and did not do so on a number of occasions as outlined above. And then in paragraph 6 at the bottom of page 9, we have the agreement that any sanction will include the respondent's good faith participation in and successful completion of a plan of training, coaching, and mentoring that has to be approved in advance by the commission chair or their designee. This also calls for reports to be made to the commission on a quarterly basis, and for respondent to authorize commission staff to communicate with the trainer, coach, or mentor regarding respondents' progress. And then finally on page 10, starting on page 7, those are the agreements about how we will proceed forward, that we'll proceed to hearing on the issue of sanction. Disciplinary counsel does agree that censure with removal will not be recommended. Obviously, the ultimate decision as to sanction remains with the panel. And of course, any ultimate decision regarding removal or suspension of a judge, is ultimately the decision of the Supreme Court of Washington, as we all know. And the parties have discussed at length and have agreed that the stipulation is not going to limit either party's ability to present evidence pertinent to the Deming factors, which of course are the factors that the panel would need to weigh and consider in deciding a sanction. And those are the same factors that are referenced in CJCRP 6C1A through H. And then we just have some recitation of what we agreed about the timing of the hearing, the dates that we propose, the proviso for either party to be able to request additional time. And then I misspoke earlier, Your Honor, and referenced 6 live witnesses when in fact we had agreed to 5 live witnesses, so up to 5 live witnesses apiece. But if respondent does not testify in her case, then disciplinary counsel may call respondent as an additional live witness. So that's where the number 6 got stuck in my mind. And then in addition, each party can submit up to 6 declarations, which are not to exceed 15 pages in length. And I won't bore the panel with the informations about fonts and line spacings. But this is everything that we have agreed to. And then finally, there's an agreement that the stipulation can't be withdrawn, and that respondent understands that if she or her counsel don't appear for the sanction hearing, then the hearing will proceed in her absence. So that is the 5-cent tour, Your Honor.
So Ms. Rasnick, before I turn to Ms. Bremner, let me make sure I understand on page 8 that's got this as you said, sort of funky pagination or something. Make sure I understand what's intended. Paragraph S is standalone. That Roman numeral bolded 2 should be dropped down, and that an agreement should be centered. And so the agreement is not intended to be at all part of paragraph S, but rather flagging the new section that starts with respondent violated the code of judicial conduct. Have I got that correct?
That is correct. That's correct. And I'm sure Mr. Gross would be able to confirm that, because I believe he was taking the laboring oar on the formatting, but that is the intent. We have section S is part of Roman numeral 1, and then Roman numeral 2 starts after subsection S and starts with A.
Ms. Colliner, you had your hand up.
Thank you. I respect that there's been a lot of last minute work, and but I just, right above that section that you were just discussing in the formatting issue, the item just above it is letter Q, subsection Q, and then it goes on to S. Is there a missing R, or is that just
There's
that's
not a
last
missing
minute?
R. I'm sorry, I don't mean to speak out of turn, but I just noticed that as well. And I believe S should be R. But I will go back and triple check that. But I think in the finalization, we just missed the sequence of the letters.
So, Ms. Bremner or Mr. Gross, do you want to add anything with respect to the comments that Ms. Rasnick has made about the
No, I think that was a good summary, and I agree with what Ms. Rasnick said about the formatting. There is no R, and the 2 should be down with agreement.
So this is as I understand it, this is a motion. I'm going to ask each counsel to actually argue the motion, why the panel should accept the stipulation, and then I'm going to offer an opportunity for panel members to ask questions about the motion. So is it principally Ms. Bremner's motion or Ms. Rasnick's motion?
I believe it is principally Ms. Bremner's motion.
Okay, Ms. Bremner, we'll give you a first and last word. Why the motion, and why should the panel accept it?
Thank you, Your Honor. And actually, I'd like Mr. Gross to address both. Thank you.
As Ms. Rasnick said, what we are contemplating here is narrowing the issues that need to be decided. I think it's important.
Mr. Gross, I cannot hear you.
Stipulation does not limit the parties from presenting evidence, and we expect there to be significant and robust evidence presented in the sanction hearing. So I don't believe that anyone is going to be deprived of hearing important evidence in this case. If the parties have agreed to this as an accurate framework for what happened, and I think the details of that will be filled out during the sanction hearing.
Ms. Rasnick?
Sure, I agree with what Mr. Gross just explained and would further explain that in the view of disciplinary counsel, proceeding in this manner allows the panel to get right to what is most important here, which is what should happen as a result of this course of conduct. So we no longer have a question about whether there was a violation of the Code of Judicial Conduct. So that is progress, and really what is in the best interest of the people of Bremerton and those who have to deal with this court as staff and attorneys and members of the public, is that there be some certainty about what is going to be the consequence going forward. And moving straight to that determination would appear to advance the aims of the commission and, fulfill the commission's obligation, I think, to protect the public. And I'm grateful that we're really able to get to the point that we could cooperatively decide to go forward in this way.
So, Ms. Rasnick, it appears to in my very brief review of the agreement, there's two things that the panel needs to consider. One is the omission of Rule 2.5 from the original statement of charges, as well as the concession that the disciplinary counsel is making with respect to sanction. Would you like to address those two aspects? First of all, did I get that correct? And
You
second of
did.
all,
You did get that correct. There was no stipulation to a violation of 2.5. And there was agreement that disciplinary counsel will not recommend sanction with removal. My understanding of the commission's process and the authority of the panel is that if the panel were to find, based on the evidence presented at the sanction hearing, that there has been a violation of 2.5A, I don't believe the panel will be foreclosed from finding a violation of 2.5A. And I don't believe the panel is foreclosed from recommending censure with removal because obviously this stipulation doesn't bind the panel if the panel accepts it regarding its decision as to sanction.
Ms. Bremner, would you like to say anything?
Yeah. Oh, don't take me off. I said nothing further. Thank you.
Nothing further. All right, Mr. Gross, I'm taking Ms. Bremner has said nothing further on your behalf as well, or would you like to say anything?
No, Your Honor, thank you.
Okay. Do any panel members have a question for the attorneys? Judge Evans.
Just one question about the declarations that are being submitted. They're up to 15 pages each. Is the plan for those to be read out loud, just as other witnesses would be testifying, or is the plan for us to just read them silently? My preference would be to hear them read out loud.
We had not considered reading the declarations into the record. Certainly that would be more time consuming, but if the panel decided that it wants the declarations read into the record, I think we certainly could accommodate that. I believe, just based on my experience in using declarations in place of live testimony, what I'm accustomed to is having judicial officers simply review the declarations, but having them read into the record, I don't have an objection to that. I do have a concern to the extent that it causes us to need more time. And I'm identifying a need to at least keep on a track that will get us to an endpoint with this.
So let me ask a question that I have then. Ms. Rasnick, you've talked about the cooperation that the council have made in order to get us to this point. What is the expectation on the duration of the testimony? You asked for long days. Have council worked together to apportion time to the witnesses and thought about it with a lot of deliberation, or are you just sort of thinking, about 2 days?
There was a significant back and forth about the length of the time necessary for the sanction hearing. I believe we were thinking about a day each. But again, there's some difficulty in being able to really hone in on that until it is known, until we've exchanged the lists of exactly who will be testifying. If we are down to 5 live witnesses each, Mr. Gross and I discussed that this morning, that it is very important that we each know who is going to be called and whose declarations are going to be submitted, because that's necessarily going to drive how long this will take. My own preference would be to get a list of who will be testifying and an anticipated length of their direct examination. I've said before that is my preference. But so as we come to before the panel right now, Your Honor, we do not have a time budget as such, but we certainly could attempt to work together on one.
Ms. Bremner, am I turning to you on that question?
Mr. Gross, please, Your Honor. Thank you.
Mr. Gross?
The contemplation was that each side would have 1 day and would organize and plan their day to the best of their ability. I think both sides are used to having a limited amount of time and trying to organize the witnesses to fill that time. And so each party could decide how to use their day. And the absolute intent of the parties was to keep this to 2 days.
What's your vision of a day? What do you think a day is? In other words, what time we starting? When are we breaking for lunch? When are we ending for the day?
I presumed we would do a day in the manner that we were contemplating this entire hearing, which I believe was 8:30 to 5. And sorry, before, because we moved on without hearing from us, we would also object to having the declarations read into the record. Given the limited amount of time that we have and the number of declarations and the length of the declarations, just how time consuming that would be and what that would mean for how much time we'd have for our live witnesses.
Commissioner Moody has a question.
Thank you, Judge Price. So just help me understand, code 2.5 is not listed here. And someone said that it's still on the table, but it's not in the stipulation. And that finding for removal is not in the stipulation, but it's still on the table. As a non-attorney, non-judge, I'm confused by that. Thank you.
Ms. Rasnick, do you want to field the question?
Sure. I can try to break that down. Commissioner Moody, the stipulation reflects that respondent agrees that her conduct violated Rule 2.8B. There is not agreement that her conduct violated Rule 2.5A. However, the commission or the panel is going to be hearing testimony from witnesses and receiving some written testimony with additional information, which goes to the issue of sanction, but the panel retains discretion. So the panel retains the ability to deliberate and to decide amongst itself. We believe that, in fact, there was also a violation of 2.5A. So this stipulation does not prevent the panel from reaching the conclusion that there was also a violation of 2.5A. And that's also how I would explain the censure with removal issue, that disciplinary counsel will not be advocating for removal, but the decision about whether to recommend that Judge Flood be censured with removal, that decision is up to the panel and is squarely the panel's decision now and always. And then it will ultimately be the state Supreme Court's decision if there is any recommendation of suspension or removal.
So Ms. Razik, do I understand that you will not be arguing that there is a violation of 2.5? You have just said you believe that there is still a violation, but are you going to be arguing that there is a violation of 2.5?
I will not. I will not be arguing that there is a violation of 2.5. At least based on what I know to be in evidence now. I will not. Certainly, if evidence comes out in the live testimony and the declarations that are going to be received in the sanction phase, and it is apparent that there was a violation of 2.5, I would reserve the right to be able to argue that. But from what I know now, I do not believe I will be arguing that.
Any other questions from the panel before we recess to consider the motion? Any further comment from the attorneys before the panel recesses to consider the motion?
And that was the issue of whether our client was on the bench with hearing a calendar when we commenced this morning at 8:30, and that wasn't true. And I did address it briefly. She had a pro tem at 8:30 that handled that calendar. And so she was not in any way ignoring this court or your honor or the commission in any way. She had arranged for a pro tem. And what she did do, she had an order from a matter that came up on Friday. She had to take care of an order on a defendant for community court on new information that came in about an available date for a bed for treatment for somebody that had been in jail for some time. So I just wanted to clarify that.
Okay, anything further from anybody before we recess to consider the motion?
Your Honor, I would just note that, any argument about what happened this morning and whether or not Judge Flood participated in a calendar would really properly go to sanction and whether or not that is an aggravating factor. And, certainly counsel should not be testifying about what her client did this morning. So I would just respectfully ask that that information be brought to bear in any sanction discussion. Thank you.
If I could just be heard on that, if there's any evidence whatsoever, which there isn't, that she was hearing a calendar at 8:30 when this matter commenced before you, I'd like to see it. I'd like to know who said that. Thank you.
Both counsel have made their statements with respect to that issue. At this point, I'm going to ask the panel to recess into a breakout session in which we will consider the motion on the table of whether to accept the stipulation as proposed by jointly by the parties.
Thank you, Your Honor.
All right, we're back on the record. I see people getting their cameras turned back on. Ms. Rasnick, are you there? Ms. Rasnick is there.
Yes,
Okay.
sorry, I had my camera covered up. So I had
Mr.
that.
Gross is with us. Is Ms. Bremner with us?
She stepped out for a second. She should be back in probably 1 minute.
I'm just going to turn my video off for a second so that I can lower the blinds that are to my left. So 1 second.
All right, well, I would like to move forward without, there's Ms. Bremner. Okay, so let's go back. We are back on the record. This is, appreciate folks' patience as the panel went into a breakout room to consider and discuss the what I'm going to term a joint motion from the parties for the acceptance of a stipulation to facts and code violations, which I'm sure as parties and those who are watching these proceedings can understand being a lengthy-ish document. It took some time for the panel to consider it as well as discuss its thoughts on it. After those discussions, I can representing the panel, say that the joint motion is granted. The panel has accepted the joint stipulation as it's presented, as well as in rough, as it's roughly discussed here, the proposal to proceed with the hearing on Wednesday morning at 8:30. I do want to turn our discussions, though, to the logistics of that. I still have a few questions in my mind in terms of this process that I understand the parties will be going through over the next, I suppose, day and a half prior to Wednesday, and when and if the panel is going to get additional materials. Ms. Rasnick, I'll turn to you. What do you expect the parties will be doing, and what does that mean in terms of what the panel is going to get in the next day and a half?
Sure. The council will be preparing any declarations, and we will be exchanging those. And I would assume that the declarations that we each intend to introduce will be filed on the timeline that we've agreed to exchange them. I closed my copy of the stipulation. I will have to open it back up to remind myself of the deadline, but I believe it was end of day tomorrow. And my anticipation is we would file them.
By the end of the day tomorrow, then they will be filed with the commission and the panel will have access to them. Is that what your expectation is?
I believe so. Yes.
Ms. Bremner, am I just turning to Mr. Gross on all these questions, or did you
All
want
of
to
them,
field
Your
them?
Honor. All of them, Your Honor. Thank you.
All of them. All right. Well, Mr. Gross, it appears that you're the go-to. What do you want to? What can the panel expect for the next day and a half?
Yes, I was looking forward in this stipulation, and I thought it was here somewhere, but I'm not seeing it. I think the parties anticipated getting the declarations to the panel by end of day tomorrow.
Okay. Now I want to tell both counsel or remind them. Oh, Ms. Collner, you had your hand up?
Yeah, I just wanted for staff's clarity, because we'll need to distribute the materials. End of business tomorrow means 5 p.m. Is that correct? I'm seeing nods. And
That's
then
my understanding. 5
That's
and
the
p.m.
then
intent. It's a pretty quick turnaround, but
Right.
that's our hope at least.
Okay, and then in regard to the stipulation itself, I totally respect that there's a lot of work that's been done in a short period of time. I've heard the parties agree that on page 8, in that Roman numeral 2 paragraph, starting at line 6, 7, and going on to lines 11, 12, there were some typos, and you agree as to what it actually intended, i.e., the last item should be labeled R, not S. And the agreement portion is kind of cattywampus. Could the parties agree on and provide us a corrected page 8 for the record?
Yes.
Thank you.
Yes.
So I was saying that I wanted to remind both parties, and Ms. Bremner, you of course, and Mr. Gross certainly were not involved when I issued this order, but on February 12th of this past year, I issued a scheduling conference regarding conduct of hearing order. And on paragraph 8 of that order, I did order that each party at the beginning of each hearing day would identify the expected schedule of witnesses for both that day and the next day. As I apply that previously made ruling to where we find ourselves now, I'm expecting that both parties will be able to provide to me on Wednesday morning, hopefully Tuesday evening, although previously I said the morning of the hearing, a list of the witnesses in the order that each party intends to call over those 2 days. Is that an expectation that I can have, Ms. Rasnick?
Yes.
Mr. Gross?
Yes.
Okay. Now, Ms. Rasnick has offered her thoughts about a schedule or an expected schedule for those testimonies. I would concur. I think that's consistent with what I previously ordered, the expected schedule of the witnesses. So is that something that I can expect as well? That not only will we have the list of each side's witnesses, each of the 5, but also the expected duration of their testimony, Ms. Rasnick?
Yes, I can do that.
Mr. Gross?
Trying to give a rough estimate, yes.
Okay. All right. Ms. Connor?
Sorry, another logistical issue to that point. We'll need to know in advance at the office the identities of the witnesses, and they need to be labeled with their names so that our staff knows to admit them to the Zoom.
Ms. Connor, when does staff need that in order to effectuate that?
Ms. Perry?
The morning of the hearing is fine. The sooner the better, but the list helps me.
How
keep
about
everybody
8 a.m.?
Perfect.
Ms. Rasnick, 8 a.m.?
Yes, that's fine. Thank you.
Mr. Gross, 8 a.m.?
Yes.
All right. Anything else we need to discuss at this point that I'm not thinking of, Ms. Rasnick?
I don't think so. Give me just 1 second. No, nothing. Thank you.
Mr. Gross?
I just want to put our perspective on the record regarding the potential of disciplinary counsel arguing for a violation of 2.5, even though that was not part of the stipulation. We believe that the stipulation narrowed the charges to just those in the stipulation, and that the disciplinary counsel arguing for violations of 2.5 would be against the understanding of the parties' stipulation.
Ms. Rasnick, would you like to put your perspective on the record?
Your Honor, I think the stipulation speaks for itself. There's not an agreed dismissal of the charge under 2.5A.
Mr. Gross, anything further?
No, Your Honor.
Okay. Well, we'll deal with that if and when it comes up. Anything else that we need to discuss? Ms. Callner, did you have anything further?
No, thank you.
Okay. Ms. Rasnick?
Nothing further, Your Honor.
Ms. Bremner?
Nothing further, Your Honor. Thank
Mr.
you.
Gross.
No, Your Honor.
Actually,
Okay.
I'm sorry. I do have something further. As was sent out to the parties prior to this morning, because we are in a remote proceeding and there are many, many people affected by this, I would request all the necessary people present, as the panel were today, to log into the Zoom at 8 a.m. so that if there are any technical issues, they can be addressed during that period of time and not interrupt with the time for the proceeding. So all the necessary parties, respondents counsel, disciplinary counsel, panelists, please log in at 8 a.m. on Wednesday.
And that also, since last we spoke, we had we've changed the way this is going in terms of the public's access. The public is accessing through a YouTube channel and no longer accessing as observers on this Zoom account. What that means is I'm going to underscore yet again each attorney's obligation that their witnesses not observe, and that they ensure that their witnesses do not observe the proceedings on YouTube. Whatever each party needs to do to ensure that that does not happen, I'm going to count on you to do so. Understood, Mr. Gross?
Understood.
Ms. Rasnick?
Yes, understood, Your Honor.
Okay. So at this point, with nothing further that I think we have to discuss, we will adjourn until 8:30 on Wednesday morning. There's a lot of work that I understand will be done between now and then, and the commission and the panel will expect to receive the declarations by close of business, and I will expect to see a list of witnesses and expected duration at 8 o'clock on Wednesday morning. Until then, we shall be off the record. Everyone have a good rest of your day.
Thank you.